Awesome, Debs. Thank you so much. Yeah, privilege that we are almost halfway through our data discussions with our data professionals from our community within South Africa, and just never ever ceases to amaze me how awesome it is and how jealous some other regions are from the collaboration and the gees, which is Afrikaans word for spirit, that we're able to have as a community. So really awesome that we are able to spend this time together, and I want to welcome Lucien. And so Lucien, we met 3 or 4 weeks ago on IT through IT Web conference. We were collaborators and speakers, and I must just, as an anecdote, tell you that Lucien was in a panel of very I want to use sophisticated, as far as I was concerned, just a whole bank of lawyers, right? It seemed like, or just people that knew a lot about law. It was very intimidating, but Lucien, I just loved it because you brought a personalized aspect to making data governance, data privacy real. And it was it's quite a daunting, when you're choosing which session to go to and you've got several tracks. It's not like that one comes out to be like, oh goody, I can't wait, let's just go and go to this data privacy. But I was very glad I was there. It was one of those evolving conversations which I really felt was valuable, and I thought that the way in which you personalized this construct of data privacy and allowed us to just invited other people's perspectives in just really kind of caught my attention. I love that. I love the fact that you mentioned an engineer aspiration, and that just made me laugh. So I want to hand over the microphone to you. Our format's going to be a bit of a presentation. We'd love to hear how you got to where you are. And then I'd love an opportunity for us to have a bit of a panel discussion. And I'm reaching out to the community to please, as we go through the panel discussion, please, I'd love to be able to take questions from the audience. If you wouldn't mind, I'll package them and try and bring them together to Lucien in terms of chunks of their themes. But today is one of those days where we get to have an awesome guy talk to, and when I say awesome because this is not legalese we're about to hear. This is about the ins and outs and the reason why it should be real, of data privacy, data ethics, and so on. So Lucien, we're excited to have you. I'm going to hand over the mic to you and look forward to the conversations we're going to have with the community.
Wow, with that intro, I'm extremely nervous now. But thanks, JG, for inviting me. And it's great to be sitting here with people I once aspired to be. I'm sure there are a couple of engineers sitting on the webinar today. So yeah, I envy you very much. Just by way of background, which is what I think perhaps that JG chuckling. I went to a really fabulous high school, and I hung out with these really brilliant kids who were outstanding at science. My dad was an electrician, so I had a great interest in technical stuff. And when I got my matric results, they were absolutely atrocious, and I was quite disappointed. I had applied to some of the prestigious universities here in South Africa for engineering. I had wanted to do aeronautical engineering and electrical engineering and all those things. And of course, needless to say, with, I don't know what the equivalent is, but a D in mathematics, they weren't going to take me. So it just so happened that I had taken it was actually just more of a joke than anything else. And I'd applied for to do a BCom law at a university in Durban. It was called Durban Westville at the time. And I was accepted, and my dad was extremely excited and sort of marched me off there 2 weeks early. You might think I'm joking, but I literally sat there for 2 weeks with people coming in to start preparations for the year, and I was in the residence like the only fellow there. That's how excited he was about me getting in. So I kind of bumbled through my BCom and didn't really enjoy it. And then, of course, my dad, being the old-fashioned type, who in our house it was, if you start something, boy, you finish it. So I had said I wanted to be a lawyer and sort of tried to get out of it after the BCom and wanted to go and do engineering. And he said, well, if you want to go and do engineering, you're not going to do it in my house because you better finish that LLB first. I'm sure some of you will remember that kind of thing. Not in my house, boy. Anyway, so I did the LLB, which is, for those of you who don't know, it's the sort of main law degree that people do, and really didn't enjoy it much. But after finishing the LLB, and that was in 1995, you, for those who don't know, as lawyers, typically you practice 2 years, or you train for 2 years, or you go and become an advocate and you train for 1 year. So I trained for 2 years with a very small human rights firm, and it kind of got me interested in law. I decided, well, actually, there's something to this. You can help people, but still wasn't extremely happy with what I was doing. And I decided to go backpacking and ended up working in a pub in the UK. And this is perhaps another life lesson for those of you out there. When I was in the UK, I had handed out, well, at that time you could email them, a whole lot of CVs. And at the top of my CV, I had put professional assistant and then my qualifications. In fact, I didn't put professional assistant, I put PA. And I couldn't get a job for the life of me. So continued working in the pub and did some other stuff. And then eventually some very bright fellow said, Lucien, here in the UK, when you put PA, it means personal assistant. And the firms you're trying to get into, I'm sure, have got enough personal assistants. Why don't you change this to associate? And I kid you not, within days, I had a job, and it was with a firm called Bird & Bird. And that's a specialist tech law firm. And at the time, I was thrown in to do all the grunt work on a big litigation matter involving British Telecom and a bunch called Camelot. And the fight was over who got the entire lottery wrong one night, or crashed the lottery, let's put it that way, because there were some technical issues that arose. And anyway, it was so interesting that I heard choirs of angels when I was working on this matter. Every day I'd sort of march in to see what next I could learn, this about networks and that about the law. So that's how I got in. And of course, when I came back to South Africa, it was around 2000. Tech, or the tech bubble had probably just happened, but media law and ICT law and tech law were like the flavor of the month. And of course, having worked at Bird & Bird in London, I was snapped up very quickly, and I went to work at Webber Wentzel. I'm going to confess now, I'm probably the only honest lawyer, but that's the one time where I didn't fully disclose. When they hired me, they asked me if I'd done lots of high-level and in-depth work, and I said, absolutely, and I described the matter I worked on, but didn't tell them that most of my work was actually photocopying and running around delivering stuff. Anyway, so that's how I got in there and made good use of it, and just grew my tech knowledge from there. So ever since, that was in 2000, I've been focusing. How do you know when a lawyer is lying? Their lips are moving. So ever since, from the time that the protection of personal information was still sort of a draft paper in 2003, and various other pieces of legislation like the Electronic Communications Act, which was 2002, I've been working on all of that and really loving it ever since. So yeah, I'm fortunate that I have this combination of getting to deal with stuff like frequencies and networks and speeds, and why didn't your network produce the 100 megs, the megabytes that you promised, etc. That sort of stuff is what keeps us going. So it's really fun, and I enjoy it because it's stuff that I love, and that's a bit of background about me. As I had mentioned earlier, when we started, you would have seen there was a flicker of lights, and had my presentation on another screen there, but it's now disappeared. So that's Murphy's Law. So I don't know if I'm going to be able to call it up again. If you'd like to, I can spend a couple of seconds doing that. But
yeah, let's try.
Let's see if I can.
Let's try doing that, because it all depends. And I mean, if it doesn't come up, it means that we lawyer biased, and if it does come up, it means we're tech biased. So it will be pretty cool just to see which way this falls.
Okay, let's see. 2023 presenting. I hope it's the right one, because I've got a couple of versions. If the Law Society pops up, then it's the wrong one.
Yeah, this one looks like the Law Society.
Yeah. Okay, so I was going to talk to them about the law firm of the future. Stop presenting. And actually, while we talk about that, JP
That would be
Morgan
nice.
did some research recently. And what they pointed out was that us lawyers are actually very endangered. Okay, I'm not figuring it out without my second screen. I'm just going to go escape and talk to the slide. What I had on the slide was a bit about Lucien, and then basically cribbed what you had on the LinkedIn profile, or the LinkedIn post, which is basically, we're going to talk about business sector specific nuances for data privacy in healthcare, insurance, and government. And then we were going to talk about 101 of data retention and usage. And the first slide that I had, it literally had the title, or has the title, Nuances of Data Privacy in Healthcare, and I have a word, anonymization. So I'm not going to pull up the slide, but just basically talk about anonymization in healthcare. Now, you might ask, why talk about that, Lucien? And I'll start perhaps, excuse me, with the Protection of Personal Information Act, which I'm sure all of you are suffering from POPIA or POPI fatigue. So I'm not going to spend more than 10 seconds on that. It basically says that health information or health personal information is special, and it has to be treated in a really careful way. How you treat it, where you transfer it, what you do with it, and how long you keep it. But why I brought that up was I came across an interesting article some time ago, and I might have mentioned it to you, JP, or not this particular example. And that dealt with research, using information for purposes of research. So some of you might remember that during COVID, there were a couple of regulations that were passed, and we all had to give our data to the Department of Health, and they were going to then use that to help us get over or out of that of the pandemic. And they used all the information that we were passing on for research and I suppose to monitor how the pandemic was going. But what that regulation actually said was, once the pandemic has officially been declared over, the Department of Health can either keep all that data, that medical data, for 6 months and then must permanently delete it, or the health department has to permanently anonymize it. And under POPIA and other laws like the GDPR, permanently anonymize means you must never be able to identify to whom that data relates ever again. Whatever that data set is, a particular individual must be forever anonymized. And while doing some research for another matter, I came across an interesting article where I think it was Pennsylvania, the government of that particular state, if it's a state, was so proud about the benefits that government workers got that they published an entire list of information relating to all government staff who were on a particular medical benefits program and put it out there in an anonymized fashion. So the data was there, how many employees were there, the types of ailments that were treated, survival rates, all of that. But what happened was there was a very clever student who managed to actually, and you data people would know how to do this, but essentially was able to drill down and identify, prove that everyone on that list at some point could be identified. And she proved it by drilling down and getting to identify all the health information, ailments, payments that had been made on behalf of the governor himself, which was quite embarrassing. So the reason I talk about that is that if some of you are in the health sector and trying to get hold of data, or are hoping to sell it or make use of it in some other way, selling it is a very controversial topic, and you're going to do it in such a way that you promise that it's going to be anonymized, well, you've got to make sure that when you do that, it is anonymized and permanently anonymized, so that we can't have the sort of situation, excuse me, that we experienced with the governor of Pennsylvania. And the reason I highlight that is because there are going to be serious penalties for anyone who misuses or promises that this sort of information was anonymized and in fact can be reconstituted. So on that particular topic, as far as healthcare is concerned, I thought I should start with that one. And maybe if you want at this point to get some comments on that. The reason I say so is because I've seen a few articles from people like yourselves where there's been a debate about how you can permanently anonymize and whether a particular method anonymizes the information as is required in POPIA or any other good privacy legislation. So if there's any comments at this particular point, come in there and let's discuss it.
Yeah, I'd love to maybe offer a comment and then a question, and also I'll just be looking at the chat to offer that. So one of the challenges with healthcare data is the level of anonymization starts to be challenged when you get very specific episodes of care being done in very specific areas. So all of a sudden, the construct of anonymization actually starts to fall down or become incomplete at a level of drill through. So, we always like to slice and dice, but there comes a time when you can intersect a slice and dice with respect to complexity, geography, time. Let's imagine 3 dimensions or more, that you can then all of a sudden start to be able to deduct. And so the dilemma that I hold in my head is, how do we make sure that doesn't happen, but how do we not lose the baby in the bathwater by saying we therefore do nothing? And so how does the law traverse this? It's almost a continuum, but yet the law is requiring an absolute. And I was just really interested in terms of how do those debates happen in the law fraternity, because we as technical professionals know that we can get the data down to the point where it fails the litmus test of that. So maybe any thoughts on that, and I'll just look at the chat.
Yeah, so definitely there are debates that happen amongst ourselves as to particular aspects of our legislation. And I'll give you an example. It's not related to anonymization because we haven't really dealt with that in South Africa. We haven't had the opportunity to debate it or to see a case study. And I suspect something is coming in the near future. And the reason I say that is because about a month ago, the regulator here in South Africa, the information regulator, wrote to the South African Department of Health saying, guys, you've still got this data, but you were supposed to delete it all or anonymize it and prove to us that it's permanently anonymized. And that hasn't been done. So I suspect if the Department of Health doesn't comply, there's going to be a bit of a botsing, as we say here in South Africa. But back to the debate. So yes, there are debates that happen, and those debates are very helpful. And the example I'm going to give is in South Africa, we have this very black and white aspect of POPIA, and it talks to what to do in a circumstance where you've had a breach or a compromise. And the law simply says, if you have a breach, then you've got to report it to the regulator, and you've got to report it to the person whose information was breached. Now think about sending, and we do this, okay, I'm not going to admit I do that, but people do this all the time. You type in the name of a person and Outlook sort of pre-populates it, and instead of a JG, it's another JG that all this information gets sent to, and it's sometimes, most of the time, pretty innocuous. But that's a data breach under POPIA, and you're required to report it. Now, we've been having a debate with the information regulator for some time to say, look, surely this is just overwhelming you, because an honest lawyer like Lucien is going to say to the client, well, the law says that you should do this, and you must do that, but we'll leave it to you to decide whether to do it or not. Now, in the EU, of course, with GDPR, they've come up with guidelines that say, and they sort of throw the ball back at you and say, well, if you believe that there's not going to be any harm, if it's very low level, and you do an assessment yourself and believe that it's not going to do any harm to the data subject, then you don't have to report it. And that's why I say that with the question that you asked, JG, there is likely at some point going to be some sort of guideline on anonymization, and we don't have them here yet, that hopefully people like yourself who are there at the, at the coalface and see the issues that can arise and see how you're hamstrung in the way you can use data, you'll have an opportunity to make submissions and to try and convince the information regulator as to what the best way would be in the circumstances that you've described. So there will be opportunities in due course. And what also happens is if there aren't regulations, and this is a very expensive and long route to prove your point, but you often get prosecuted. Well, you will get prosecuted. And if you have good enough lawyers and if there's a sufficiently strong case, you would convince a judge that in those circumstances, you should have been allowed to do it because there was no other way to use that data. And what then happens is you weigh up the benefit to the public interest versus that individual. And a judge might say, look, the fact that we are able to identify these 3 people in Pofadder or Kuruman or Carolina, these small towns, shouldn't prevent us from being able to make progress in using this data to help humanity. So those are the 2 routes. One, guidelines get passed and you get an opportunity to make input. And the other, court cases happen. And sometimes judges are convinced that you were right and the regulator was wrong.
So that's really interesting. Whilst you've been chatting there, there's just been some debate and some discussions regarding the construct of what looked like anonymization and obfuscation. I think anonymization and aggregation. How would you differentiating between those two? Is there? Do you want to just unbundle that for us?
Basically, when we aggregate, we remove the feature, the identification feature. But then what we have to prove is that they can't align that data with other data sets to get the individual items. So the simplistic example, and I've seen this driving around America, you drive through a town and they've got 127 people in the town. Now, they then publish categories of ages to say, from 80 to 90, these were what the people are like. And then you realize there's only one 80-year-old in the area. Well, now you've broken it because they've aligned multiple data sets to bring the detail down to the right level where we can say it was that person. Now, what I'm concerned about is anonymization is we could either aggregate it and get anonymization, or we could obfuscate it in a way, or by removing it or overwriting it or changing the ID or whatever it is, we can do that. But once again, we have to be able to prove that no one can realign the data set on another feature and give you all the details that you're looking for. Now, the question I have for Lucien was, if that person, if they initially aggregated it to just have statistics, they rolled it up, then somehow she must have got data from somewhere else, and that somewhere else must also have been sharing data illegally, because in a privacy point of view, the default is that individuals keep their health information from disclosure. So somebody else must have given her a data set that went down to people. And who is that other person where she got the data set from?
Yeah, so that's I tried to understand, and that sort of falls into you, the statisticians and the data analysts, into your field. It was, and I'll post, I think it was by the Harvard Law Journal or whatever, in the chat a little later, and you'll see how she managed to do that. But essentially, you're right. She went in and used postal addresses and a whole lot of other publicly available data, and somehow came down to being able to identify himself. Yeah.
All right. Okay. And there was a fantastic. We use a fantastic data modeling example of in Ireland, where they had voting and they had census data, and they were able to connect the two on the GPS location and address, and they could actually say that person voted this. And so they got all of the exposure to all the voting results.
Yeah, it's very possible. I mean, you'll remember about 2 years ago, there was a big debate about matric results and whether they should be published. And one of the arguments that convinced the judge to allow the matric results to be published was that nobody would know who a particular exam number related to if it was in the paper. And they said it was anonymous. Now, to your point, all it would take is for a hacker or some malicious person or somebody negligent to drop a drive or something, and it happens all the time, and for somebody to be able to access that and have the personal information, names, dates, ID numbers, connected to that exam number, and there you go. It's not anonymous anymore. So there's a difference between anonymizing, which is a permanent means of de-identifying a data subject or person, and then there's pseudonymization, where you allocate a particular code and you still have all the information that that code is connected to. The example I give is of that fabulous story last week of our olive farm in the Karoo that won best olive oil in the world. And in that instance, it was a similar exercise where they pseudonymized. The judges were given literally just a number, and they had to judge all these olive oils in the world. But you could ultimately trace who the producer was. So that's pseudonymization versus anonymization. And what our law wants is if you're going to be putting health data out there for research purposes, it must be permanently and irrevocably anonymized.
So maybe that's before we leave healthcare and go on to insurance. That's a good way for the construct of data. Sorry, just lost data, synthetic data, and the ability to solve the anonymization or the challenge with respect to or the sensitivity of the data by generating synthetic data, which is it's got great well, there's a great level of interest in synthetic data at the moment, because if you do that, then you don't have to waste real data with respect to training, learning algorithms, etc. And I was interested as to how would, because in essence, I think technically we're going, we could, we're going to go through syntheticizing the data, putting a synthetic overlay on the data, and being able to get rid of the sensitivity of the personalization. But then the legal teams would almost need to set the standard of what's enough, because when it comes to the synthetic process, there's mapping, there's the protection of the mapping, there's potentially the destruction of the mapping, there's got to be potentially a value key pairing, and then once that's taken place, potentially an adjudicated process where you actually delete that so that you can never get back to the mapping. So when these initiatives come about, they're quite technical, they're quite sophisticated, they've got great use cases. And I was chatting to a person I've spent many years working with, and they're currently at Discovery. And there's there's great intention to figure out how to do this, because Discovery recognizes this as a great risk of their business. So, Lucien, just as we're closing out on healthcare and we see these new technologies come in, do the lawyers feel like they wait for the problems to happen? Is there like a front foot engagement? How do we go about making sure that we never lose sight of our ethics lens when it comes to evaluating, considering these new technologies? At what point does the legal team get involved, or do you feel like it's usually on the back foot?
Yeah, lawyers are, yeah, to a certain extent, we're very old-fashioned. We just sit in our comfort zone and we wait for people to come to us, which is bad. And the reason I say it's bad is we should be encouraging our clients to come and speak to us up front while you're in the early phases of planning whatever it is that you want to do, using the complex example that you gave. come and speak to the lawyers earlier, not because I want work from you, but simply because you don't want to spend a huge amount of money to get to a particular point, and then the lawyers shoot it down, and that's the end of that. So yes. Rather very early on, and the law says that exactly, privacy by design and privacy impact assessment. Correct. It popped up on my screen. I was getting to that. Undertake that exercise right from the get-go, and what that might allow you to do is actually to tailor the process and what you're doing, so that you don't reach a point where you're stuck and you just have to give up. I think the legal guidance should be investigated right from the beginning, lawyers typically just sit back, but maybe we should do more to encourage people to come and see us, particularly in these complex fields early on, so that we can perhaps guide you through it and find a way within the law to achieve what you want to achieve.
Lovely. We're about to leave healthcare, but I can't help Marcel's point. Marcel, if you can come off mute, it would be lovely for you to pose your question. Otherwise, I'll read it for you.
Yeah, thanks, JJ. My question is just, in various discussions, it came up that, so we look at destroying our data after the expiry of, you need to destroy it as soon as, well, you're only allowed to keep the data as long as reasonably required for your business processes, and thereafter you need to destroy it. So, but now you have to have proof that you destroyed the data. So, and that, what you said there was just intriguing me about, and the linking of the data, So would you be able to trace it back from those audit logs to the original data that you then destroyed? Or when you destroyed it, is that destruction process permanent? Was just interesting. I just thought of the idea.
Yeah. Sorry, my phone was going mad with. Anyway, I've switched it off. So as far as data destruction is concerned, what the law says is that it must be permanently destroyed. In other words, there must be no way of ever putting it together, reconstituting it, and being able to identify who the data subject is or was. So you need to decide what permanent destruction is. And in my mind, as a lawyer, I would imagine that if you've got a hard drive, you would crush it and smash it and incinerate it, and that's permanently destroyed. I think it's as simple as that. And I like your point about getting certification as to how it was destroyed and whether it fulfills a particular the Act's requirement, POPIA's requirement, and different things, different levels, I suppose. People apply different levels to how they destroy this sort of stuff. We, for example, make sure that when we shred paper, not that we use much paper anymore, it's done on our premises and we actually watch it and we get a certificate. I'm always paranoid, and I say to clients, if you're sending stuff away, whether it be your hard drives or your paper to be shredded, how do you know that somebody is actually doing that? And all you can do is rely on that certificate. And let's say somebody says that they've destroyed your drives permanently and all that data on it, and it turns out that they didn't. There's a good chance that if you end up before the regulator, you're the one who's going to have to do the explaining, simply because you were the responsible party. And if you do get a fine, which is highly likely because we have what is called strict liability in South Africa, you then will have to go after whoever it was that gave you that dodgy certificate. So anyway, the point is you've got to do your absolute utmost to make sure that what you expect is actually being done. You can't just say, well, they gave me a certificate. So it does put a huge onus on you to ensure that whatever is required is actually done. Does that answers you, Marcel?
I'm just thinking so you have a server room, so you have databases with records on your databases, and certain of those records have an expiry date on them, and you have to delete those records. So typically HR records, a person has resigned, so you must now permanently delete that person's record from your systems. And then so you will do it from internally, but then you have to have audit logs that you have permanently deleted or destroyed that
Yes.
data.
Yes.
And my question is, the first one was, can you trace the information back to the audit log? I think that was my first one. And then, yeah, that's actually the question, just if there is traceability between the audit log and the destroyed information. Like you explained that, how to explain that there's a linking that you can do between certain data sets to bring back to get to the identified person. So that was kind of what I was looking for.
Okay, so just so that I understand it, and by the way, none of this is legal advice. Don't ever sue me if it's wrong.
Oh, but you're a lawyer.
So as I understand it, Marcel, what you're saying is you have these audit logs all along that record that there was a particular data relating to an employee. And then at that point, just so that I understand it in my head, you then delete all of that data, and those audit logs then show that that data is no longer there. Am I on the right track so far? Am I correct? Going forward,
Yes.
the audit logs will say there is nothing on that server. So is your concern that the pre-deletion? Sorry, go ahead.
Let me try to add a little bit more detail, Lucien.
Yeah.
What we do a lot is let's ignore employees and stuff like that. But our whole way of dealing with customer data is that we go through a process of archiving from the application,
Yes.
and then that would still, the transactions or the sales to the customer are still in a data warehouse of some form.
Yes.
And at a point in time, we have to aggregate the data to a sufficient level where the individual can no longer be identified. So this is the journey that our data goes, where you still want to keep an aggregate of the impact that they have in total, but you want to ensure that they can't say, you did this and stuff like that. And that's where a lot of the problems come in is, okay, you've informed us that you have a right to erasure or whatever it is that, and you can say, please get rid of my data. We have to be able to remember that you've asked for this, and B, ensure that no one can see your data again. We can't get back to you in any form. Now, Marcel, I see that slightly different to that of a disposal of physical of documents, electronic documents, and then also the deletion of those underlying records that make up the aggregate. That deletion would be managed by, when we delete from that warehouse, we would say, these are all the IDs, and you can have a surrogate key ID and not the actual ID of people that were deleted, and you'd have a lookup to say, wherever it is, customer ABC, this was their surrogate ID, and the data was deleted at this point in time from these tables, and that's the sort of scenario that you'd go through.
That's how I imagine it from a legal perspective. Up until this point, you've got this data. It's sitting on a section of your hard drive. Your logs show that Lucien Pierce's data was in this particular folder, or whatever you data people call it. And after that date, it shows that Lucien Pierce's folder is empty and there is nothing else there. From my perspective, that's what I would say to a judge. I would say, Judge, up until this point, there was a folder and it had, 700 kilobytes of information, and now it has 0. And all that information is gone. Even Lucien's name is no longer on our server, as you can see from these logs. And for me, if that's done and it's permanently removed, that would satisfy anyone challenging you.
Lucien, thank you so much for that. I'm going to ask us that we, if everybody's comfortable, the healthcare examples offered a really great deal of detail and great insight with respect to the sensitivity of people, and we can all relate to it. That's awesome. Maybe we can head across to another use case where
Sorry, JG. Maybe I wanted to make an important message here, and As part of the oversight and containment of data governance, we need to make sure that whenever a data product is designed and thought up, we need to go through the privacy by design phase, and we need to prove that we've done that, right? So as part of your governance, this is not a legal thing. I mean, it is a legal thing, but it's not a legal thing, right? We as governance and compliance people, we have to demonstrate that we've gone through these privacy by design, and if we aggregate an archive, then they can't get it back, and all those type of things. So that whole thing that's, remember, we have it in the value-driven way, where you do a strategy for a product, then you go into oversight to see, well, like, for example, if we go open data, JG, if we were to publish open data, and typically what you'll do by open data is remove the citizen information, right? So it's not visible, but now you have to prove that you can't re-ID the citizen by aligning another data set in that type of thing. So we must remember, as governance people, you've got to be on top of this thing. You've got to ensure that it's been done, your privacy by design has been done, and your privacy impact's been done, assessment's been done. We can't say to the lawyer, please help us, excuse us from doing this, or can we do it? They need all of that detail in the assessments to judge that you've done your homework.
Yeah,
it's a great point, Howard. Thank you. Yeah, so just this construct of a data product actually has that as an integral part of it, and you can't subordinate that responsibility. So holding that thread into the next construct of a data product sitting on top of insurance. So in healthcare, we were looking at the anxiety that a patient might have if their data records aren't well looked after. What I'd love to explore in this use case for insurance is there's this de-risking or an associated risk that can be deduced when you start bringing multiple data sets together. And, there's a really established and successful company in South Africa who has a very big market share, and everyone's forever contesting whether they have true Chinese walls between them or whether they look across. And so, Lucien, I'd love to just get a perspective of how the legal fraternity comes to this insurance environment, where it would be super useful for the insurers to be joining information to de-risk, but that could at times fall foul of the what we of the protection that we're allowed. So can I just ask that you just kind of sketch a picture of insurance and maybe take us through some use cases that you might have experienced, just to give us flavors as to what's happening here and how as we data professionals can respond.
Sure. Okay. So for me, from a legal point of view, the section that immediately comes to mind in our law, in POP here, relates to what we call profiling. Because I imagine that as an insurer, you want to create a particular profile of a particular group of people to determine, what their propensity for a particular illness might be. And that might then determine whatever premium is applied, when they apply for health insurance or any other type of insurance. So is that sort of the example that you're thinking of?
Yep.
And of course, as you say, it would be very useful if different insurers could bring together, the data that they have to create these even better profiles about, potentially the target market that they're trying to capture. But what our law says is, when you're taking data from different, completely different people, if I could just use that term, you might be going to an insurer, you might be going to a gym, you might be going to somebody who organizes cycle races, and collecting all those types of information, perhaps even checking on social media to see whether somebody, has lots of pictures of themselves at parties drinking lots of alcohol. And you take all that information and you combine it together to create a profile. Our law regulates that. And it says, if you're doing that, you're going to have to get prior authorization from our information regulator to build up these profiles. Now, if you've got these two insurers that you gave the example of, I imagine that if they are combining this information and and they're regarded as two different sources of the data, two different responsible parties, to use the language of the Act, if they are combining it to produce a particular profile, then I suspect that they either are falling foul of the law or they have applied for prior authorization to do this. It's typically the trans unions and the just gone blank, the other guys with the E in their name.
Yeah,
they had
Experian.
Yeah, the trans unions and the Experians, who are required to apply for prior authorization because, you know, to use old-fashioned examples, they would send somebody off to the court to go and make photocopies of the recent judgments suffered, and they would go to the police station to see what list of collisions they have, and they would combine all of this to try and create a profile of all, you know, all the people that they have on their database. And because they're doing that, they need to get this prior authorization. So back to your example, JG, I think that if this is indeed being done using the example of the two, they would need to look at that section of the law and make sure that they are on the right side of the law to do that. You know, could well be that they've obtained consent from the data subjects to do that. That might make it legitimate. I don't know if they've got that. I would need to see their terms and conditions as to what they've gotten there. You know, the people whose data that they are processing, what they've got them to agree to. So yes, profiling a very, very sensitive area across the globe. GDPR places great emphasis on that to ensure compliance because it can be very dangerous for individuals. It allows people to build a particular profile about them and then to use that potentially adversely against them. You know, there's a real life example of social security, a social security case in the Netherlands. And in this instance, what happened was the tax agency of the Netherlands used artificial intelligence programs to create profiles based on where they lived, based on the fact that anybody who was of North African descent had a particular or more risky profile, and they put all of this together and created obviously profiled everyone. And the problem there was that it ended up being a very biased way of determining who was high risk and who was not. And people were then either potentially accused of being involved in social security and tax fraud, and in many instances, a lot of people were not. So that's why profiling is regulated in such a way, because it can have enormous consequences for people. Take those insurers. If they create a profile and the data it's based on is potentially incorrect, I could go and apply for insurance and just be refused, and I'm entitled to ask why, but that already starts a whole problem for me.
Understand, absolutely. Howard, hand up.
Yeah, JG, it starts to also go into an ethical debate, because what can happen is, you know, the impact of that profiling, and it can cause me harm down the road, 6 months, 8 months, a year, you know, and then you have to prove that, you know, you not just this privacy impact assessment, but also an ethical impact assessment. What damage can you cause? And they can come at you for the damage that you've caused in their life. So we must remember that it's you know, it's also then goes over to not just maybe the misuse of the data or the fact that you've got prior authorization, but if you cause damage, you've got another issue to deal with.
Yeah, absolutely. Yeah, I was going to say, and at the moment, the Dutch tax agency is the subject of huge lawsuits arising from this this mistake that they've made. Yeah.
So that's really interesting, Howard and Lucien, the way you paint that picture. It's almost like this layered approach. There's consent, and you either do or don't have it. But then there's this, you know, do no harm. You know, I just think of that chapter of the DMBOK. It's you know, there's those 5 or 6 points, and what this discussion has really helped me understand is those layer they come at different times, they happen in different sequences, and they have different consequences as and when they come together. So
and
yeah,
JG, one of the experiences we're getting and feedback we're getting from customers is that managing consent is not easy. That ongoing consent and ongoing usage in terms of defining exactly what it's for and then changing it and things like that. So we mustn't underestimate the effort we put our business under to keep that consent going.
Yeah, that's critical as well. You know, and there's another aspect to insurance as well. I mean, if you think about insurance from a claims and a fraud perspective, there's been a huge move in that direction to collect data from publicly available sources like social media, etc.
Yeah.
And again, in those instances, you know, consent is required. And if you don't have that consent, there are going to be huge issues for you as well. Forensics departments within big corporates, looking out for you know, corruption and fraud within the organization, are starting to try to predict in advance who is likely or where there are likely to be frauds that occur.
Yeah.
And again, you know, if you're doing that by looking at an employee's history, looking at their social media profiles, who they know, who they hang out with, that also could have devastating consequences, which is why, again, getting that prior authorization is, you know, our laws insist on it.
So I guess it's maybe just one more question / comment with respect to insurance, and I'd like us to just also consider the government before we run out of time. But almost like there's this corporate desire for example, insurance. We want the price of insurance to be low. We know that the price of insurance is high because of corruption, fraud. So for the mass market, we actually want to cheer the fact that there are fraud engines and there's this desire and we're hoping that as a result of good governance by the insurers that we eventually see the price reduction in the premium. It's our hope and intent. Imagine that does take place. It means that we as the mass consumer are cheering initiatives like fraud reduction and fraud interrogation and so on. So that's a good thing. But then all of a sudden becomes a bad thing. And it's this construct of there's this continuum of it's a great thing and then it's a bad thing. And you know, where do you draw the line? And I guess you know, that's it's almost, as I think about that, I see that that's the legal team's challenge is how do we be representative but fair? Listen to the masses, but fair to the individual who could be prejudiced in the isolated event. You know, so when you debate that as you know, with your legal colleagues, you know, what's your mental model as to where do you know, who do you support, the masses who want it or the individual who might be prejudiced?
No, it's you know, what is in the public interest. And to use an example that is unrelated to insurance, there was a case fairly it was sometime last year or the year, so you might have heard of it, but it related to a fellow who ran a farm, and on that farm his livestock was being attacked by either hyenas or jackals or something like that, and he laid traps on the farm. It so happened that these traps were very close to a mountain biking trail, and a couple of mountain bikers rode past a few times and kept noticing these animals dying terrible deaths in these traps. And they took pictures and publicized his farm and his name, etc., etc. And it went to court, and he accused them of invading his privacy and a whole lot of other claims as well. And in that instance, what happened was the court weighed up, you know, what is in the public interest, whether this fellow should be entitled to his privacy or whether the public should be aware of the fact that he is cruel to animals and is not doing, you know, I can't remember the exact argument. So if he does listen to this, I'm qualifying this. But that was essentially what was weighed up, and the public interest prevailed. So I think in your insurance situation, it would potentially be a similar argument. You know, what's nice about our legislation, our act, is it opens up and it says, you know, something to the effect of we need to respect privacy, but at the same time, it should not stifle economic activity. So there's a balancing act that needs to be struck. So it's not just going to be completely no ways you can't do it. There's going to be a balancing act of sorts that needs to be undertaken.
And JG, maybe to add something there as well, is whilst a lot of times the lawyers will give you a ruling on whether that's going to fall foul of any privacy act, that doesn't mean it's ethical, and you may not be picked up from a different angle, right? So we must understand this. Okay, this action may be legal, but is it appropriate and is it ethical to does it cause any harm? We sometimes cross over that line.
With you.
Yeah, that's a factor as well.
Maybe can I just use this, use the momentum that we're on to introduce the third use case with respect to government. And there it would be really interesting just to get your opinion regarding, at its absolute fundamental, governments to serve. Therefore, the collection of any data is should be done within the auspices of the greater good, and should be used in such a way as to make our not environment, our communities. There's another word. Communities more effective, more efficient, more sociably aware, and so now we enter into the realm of the data's collection is actually for the greater good. But in our context, we realize that data in the wrong hands is tricky, and we also concerned that sometimes our government is, the people collecting the data are not looking after it to the degree that some people who assess its value might go after it. And so here you're in this dilemma with respect to the government's trying to serve us. The data should be actually available to us. It should be offered to us. And Howard, you mentioned open data. It's what point is there an obligation from the government to publish data in a responsible way that actually makes it more effective for us to be economically viable and explore options within our country? And so like all of a sudden, when you look at it through a government lens, we've got this construct of sharing for the greater good or collecting for the greater good. And I would just love to see how where do you put guide rails in with respect to that?
Yeah, so it's not a new issue or topic at all. Some of you who might be following what government is doing about progressing towards the fourth industrial revolution and the digital economy and all those things. There is a lot going on in the background, and one of them, and it's not in the background, is the state's draft cloud and data localization policy. I'm not sure if any of you have had the opportunity to look at that.
Yeah.
But if you have, you will note that there is a push towards doing what JG is raising, making certain data sets, I hope I'm using the right term, or databases available to the public to allow whoever is in that field to use that data for the benefit of South Africa. So it is stated very clearly, in the draft policy, government must do whatever it can to make data available in a safe way. In other words, it mustn't prejudice whoever the data relates to, so that it can be used to achieve purposes, whether it be commercial purposes or public benefit purposes or whatever it is. What is emphasized, though, is that it must be held securely. That is absolutely critical, and kept for only so long as is necessary. The usual requirements that you find in privacy law. But it makes a very interesting read, because what it also talks about is the sharing of information, because at the moment it's recognized that data is very siloed. It is very difficult for government to use data from one department for purposes in another department. And they talk about that sharing, having one sort of seamless database. I find it interesting because I was on at an event at the United Nations. It was online. I wish I'd gone to New York, but no, it was online. And one of the points that was made, I think it was either Estonia or Latvia, and they were very critical about having this seamless and combined database, because their approach is they keep the silos, and only where specifically necessary and authorized do they have this sort of communication between the various departments. I think because they have this fear that the data could be misused, as you've pointed out, JG, by malicious people who have really bad intentions. So there's this debate, do you combine it all, and is it more useful, or do you keep it siloed and only use, I suppose, cross-pollinate or share in very specific circumstances? But I'm a firm believer in making all of that data available for use, whether it be by commerce or any other sector, if it's going to benefit everyone.
I'm just thank you, Lucien. I'm just looking at the chat. Gaucher, you've just mentioned this construct of bias and ethnic. Do you want to? Are you having a conversation with Howard? Is there a side? Gaucher, is there a question that you want to pose to Lucien?
Yeah, thanks. Yeah, it's about, yeah, as the last statement was, it's about the biasness that we all of us. So when we get to the design, and Howard, you mentioned it in the beginning, is when you start off your design, your design for your application, whether it's for use of, aggregation, or use of transactional based, or maybe used as a record keeping, you must keep all those biasness, let's call it biasness, into consideration when these things go. And the other thing is maybe on the anonymization thing, just so can you not anonymize a data set by removing the person's name and first name and second name, as well as his social security number or ID number? Is that not the one fit for all that you then ultimately never will get down to, ultimately get down to where you can re-index or re-lineage, rebuild lineage, because it's about lineage. So if you have an exemptional circumstance, for example, we've got the 81-year-old Indian walking in your village. So everybody knows this guy, whether you have looked through a data set or no data sets, this guy is Indian, and we all guess he's 81. So I mean, so if you do the data lineage, where you do your profiling and things like that, that will confirm whether or not, or would it not confirm whether or not you have then completed the myth of able to re-index by a clever data analyst or re-identify things. If you remove those top 3 things of someone, isn't that basically what we want to remove for everything?
Gaucher, that's precisely what happened in the example I gave in the US, in Pennsylvania, of that governor. They removed names, they removed surnames, they removed social security numbers. I'm not sure if they removed sort of address, general address or postal code, but that researcher, notwithstanding those 3 very important identifiers being removed, was able to re-identify everybody, including, well, she didn't reveal everyone else, but to prove her point, she was able to identify the governor's set of data. I'm just going to try and find that article so I can post it in the chat.
Thank you.
Gaucher, what the important thing is you have to be able to see. It doesn't matter that you remove those elements, right? It's a case of, can they, by aligning another data set, pinpoint you and then recreate it? So it's not about bias. It's all about, can I get back to the original person and then understand who it is? So it's really about, if I join 2 data sets, can I find the original?
But would that not be picked up when you do your data profiling? So if
No, because remember, it may be other people's data sets. It may not be your data set, right?
but who does the profiling?
No, but
You,
it's
the
not
person-
important about the profile. Let's just go one step at a time. Let's say I've got 1,000 records, and I take all these people and I remove their personal information. So PII, I can't identify them. If they could use data from another ministry, from another source, and they're able to recreate it, and and the original ministry exposed the data, it doesn't matter about their lineage and their profiling. It's got nothing to do with it.
So you're talking about using external data sets that's not part of
Yeah.
your data set.
Yes,
Yeah,
correct.
but then it's going to be never possible.
Yeah.
Well, that's look,
think.
de-IDing, being able to prove that you cannot get back to the original is extremely hard. And they're saying that, basically you should be very jaundiced of the fact that you can never re-ID a person. So that's a big warning flag, and we must all protect against that and be very careful. You have to mathematically prove that you cannot get a re-ID. Mathematically. That's what people have to do.
Okay. Some sort of clever machine learning tool will then help us to do that.
Yeah,
With
yeah,
all the
yeah.
entities and stuff.
Yeah, correct. Correct.
Thank you.
Lucien, I see that you've been able to. Thank you so much for that question, Goshe. Howard, thank you for that response. That's awesome that you've been able to just get that for us. I am aware of time, and so we're basically wanting, I'd love to just maybe wrap for a moment and then give closing comments to you, Lucien. But what's been really interesting is 3 case studies. You highlighted the word anonymization for the health. You highlighted the construct of profiling for insurance, and I picked up the word transparency for the government. And what I thought was fascinating is just those 3 words literally created a plethora of items to consider and think about. Howard, I thought what was really interesting was here I am saying, hey, Lucien, what do you lawyers think? Howard's going, hey, listen, data product designer, did you think about that? A lovely reality check of responsibility happening right up front at product design. And I thought that was really useful, that construct of privacy by design and privacy impact assessment. So that's been a key take home from me. Lucien, I'd like to give you the closing comments for our session, and then I'm going to tell everybody what's going to happen next week. But just anything that you'd like to just leave the community with closing thoughts, Lucien.
Yeah. Look, I think what you're doing is the future. Everybody on this chat, I think that data and our ability to use it is going to change society. We've got to be responsible about how we use that data, and that's why we need these laws in place, these guardrails, to make sure that it is not misused. But I think that if we can, and I'm focusing and I'm doing some work on our country's draft cloud policy and data localization policy. If we can get that right and make sure that we use it to our benefit, and the example I gave is of making government collected data sets available to the public. If we can do that in a responsible way, then I think there are great things that we're going to see in South Africa. So, yeah, that's just my closing comment.
Awesome. Thank you so much. I'm going to wrap our session. Just to say thank you to the community, and let's just never lose sight of the fact that we are a community of data professionals passionate about what we do. How awesome is it to be serving together, sharing together, and just let's not take that for granted. Thank you for joining today's call, and we look forward to just a continuation of this discussion next week. And so, Lucien, I just want to thank you. Really appreciate it, and thanks everybody for participation on the call today.
Thank you.
JG, you were going to tell us next week what's happening next week, or
I realized it's me.
Yes, correct.
And I went, oh shucks, I can't really advertise, can I?
Yeah, no, of course you can.
Come next week. So next week, what I'm going to be doing is offering you a view of the presentation that I offered at the IT Web conference, and that's in particular with when you consider the alignment of to a business imperative. Imagine taking your data management policies and aligning it to a country initiative. Imagine trying to get that level of alignment and allegiance at your data management level such that it realizes country goals, not just business goals, not just industry goals, not just regional goals, but country goals. And so that's what I'm going to be taking us through, is imagine vertical alignment at a country level. And I'm going to be highlighting some of the observations that we've had in Saudi with respect to how one does that and the purposefulness with which one has to do that. And so come next week, it'll be exciting. We look forward to hosting you then.
Lucien, thank you very much.
Cheers, everybody.
Thanks, JG. Thank you very much. So thanks, everybody.
Cheers, team.
Thanks.
Thank
Take
you.
care.
Bye.
Bye-bye.
Thanks,
Bye.
Lucien.
Bye.
JG. Right. Thanks, guys.
Bye.